may I request that we all then remain standing to observe the opening protocols for this session this morning through the singing of the national anthem and the recital of the preamble of the Constitution. We are going to be requesting Ms. Kolegas Kenjana to lead us on the singing of the national anthem, immediately then followed by Nathaniel Chetty from KwaZulu-Natal and Sihlelelwe Khoza from Mpumalanga, who are going to lead us on the recital of the preamble of the Constitution. We remain standing for the recital of the preamble of the Constitution.
We, the people of South Africa, recognize the injustices of our past,
honor those who suffered for justice, and freedom in our land.
respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it. United in our diversity.
We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic,
so as to heal the divisions of the past, and establish a society based on democratic values, social justice, and fundamental human rights.
lay the foundations for a democratic and open society, in which government is based on the will of the people, and every citizen is equally protected by the law.
Improve the quality of life of all citizens. And free the potential of each person.
And build a united and democratic South Africa. Able to take its rightful place as a sovereign state.
Able to take its rightful place as a sovereign state.
And the family of nations.
The family of nations. May God protect our people.
May God protect our people. Nkosi sikelela iAfrika. Morena boloka setjhaba sa heso.
Godsien South Africa.
South Africa.
God bless South Africa.
Modimo fatutetsa Afrika.
Modimo fatutetsa Africa.
Hosi katekisa Afrika.
Hosi katekisa Africa.
We thank you.
Thank you. You may all be seated. Thank you very much for leaving your beds this morning in such a cold weather during springtime in South Africa to join us for this inspirational session that is going to be led by our young people. This is the National Schools Moot Court Grand Finale, which is a program that is a partnership between the Department of Basic Education, the Department of Justice and Constitutional Development, and the South African Human Rights Commission. It is a program that is the anchor of our desire for constitutional rights education, human rights education, and equity in education. At this point, I'm going to request that if you've got your mobile device with you in this room, that from now on, please just keep it in check, put it on silent, or switch it off if you don't know how to put it on silent. And I'm going to then request the bailiff to help us as we are going to be introduced now to the justices and the judges that we have for this morning session. Over to you, bailiff, introductions.
All right. Introducing to you our judges for the National Schools Moot Court 2025. In the matter between Tango Kumalo and others versus the SGB of Phil and Zebra High Schools and others, this court is now in session. Introducing your judges from the middle to the side, Justice Colabel, Justice Cotterill, Justice Stefo, Justice Dlamini, Justice Rutten, and Justice Adams. Introducing the judges on the side, Justice Moot, Justice Miller, Justice Harvey, Justice Duplessis, and finally, Justice Mzalana Mese. You may be seated.
Thank you so much, bailiff. Thank you for the introductions. At least they can put a name to the face, and they don't have to be as nervous as I am when they are going to take the stand. We are going to request then a representative from the South African Human Rights Commission, Professor Tsepo Madlingozi, to render the welcoming and opening remarks.
Good morning. Dumelang. Hey, you are so nervous. I can't even hear you. Sadibonan. I wish this was facing this way because I want to speak to the learners. But first of all, let me start by welcoming and recognizing our Deputy Minister, Honorable Andries Nel. Honorable Deputy Minister has been with us for 14 years as an unwavering supporter of this moot court. In his first stint in this position, but certainly even now. So, Deputy Minister, thank you so much for your commitment to this competition. Secondly, let me recognize the bench led by Chief Justice Kolapen. May I just say that we are so proud of the South African Human Rights Commission because Justice Kolapen is our former chairperson at the South African Human Rights Commission. Thank you so much, Justices, for leaving your bed, for being with us this morning. And I'm sure I speak for all the learners when I say we are truly honored that you have joined us today. Thirdly, to our partners, the Department of Basic Education, the Department of Justice and Constitutional Development. Certainly, it has not been an easy journey It has been full of ups and downs, and we are here today, and thank you so much for your continuing commitment to this project. On a personal note, I remember quite vividly when Professor Christoph Haynes came to some of us at the University of Pretoria more than 14 years ago with the idea of this Moot Court as an iteration of the All Africa Moot Court. And of course, he took it to the faculty board and it was accepted. So on a personal note, it's been truly an honor, and I wish for us to, at this moment, recognize Professor Christoph Haynes for his vision and for this leadership for coming up with this Moot Court. Esteemed guests, welcome to this session. We are going to witness another historic iteration of the National School Moot Court competition. But finally, to our learners, as I said to you on Thursday, just by being here, you are already winners. And can we just give them a round of applause, please? So we are applauding you even before the competition starts, because just by showing up, by putting up your hand and say, I want to participate in this competition, you are already winners. Let me cite this famous quote. I'm sure some of you know this quote from Franklin Roosevelt. And he says, "It is not the critic who counts, not the woman who points out how the strong woman stumbles, or where the doer of deeds could have done better. The credit belongs to the woman who is actually in the arena, whose face is marked with dust, with sweat and blood, who strives violently, who errs, and who comes short again and again, because there's no effort without error and shortcomings, but who actually strive to do the deeds." End of quote. So I want to say to you, you all deserve the credit. This is your space. This is your arena. Take your time. Speak slowly. You are allowed to ask justices to repeat the question if you didn't hear the question. And as I said, it's not about winning. It is truly about participating. I remember when I took part in the Moot Court long time ago, the All Africa Moot Court competition. And we went all the way to Ghana, where we came second place. And it was the start of the change of my life and this trajectory that I'm on now. So I hope this day will be a start of a historical shift in your journey as future social justice warrior and human rights lawyers. Let me leave you with another quote from the Bhagavad Gita. And it says, "Therefore, always perform your duty efficiently without attachment to the results, because doing your work without attachment, one attains the supreme." So with those words, let me welcome all of you to the 2025 grand finale of the National Moot Court competition. On behalf of the Department of Basic Education, the Department of Justice and Cultural Development, the South African Human Rights Commission, I declare this competition open. Thank you so much.
Thank you, Professor Madlingozi. In case you're wondering how they landed here, they've had a very long journey. These learners are drawn from the learning areas of life orientation, social sciences, history, English first language and English first additional language and English home language. Sorry, I almost sounded like an old stock, because we had English first language and English second language. So they write essays at school level about the cases, then they submit those essays. They get marked at a school level, then there is a process of elimination, and they choose the top 20 essays that get sent then to the district. And at the district, they undergo another round of critiquing in their essays. Then there is a selection of those that must actually come now and do what we call oral presentations at the magistrates' courts. Again, there's another process of elimination that happens there. And then the essays and the oral presentations then get selected, and they're all sent up to the province and national. Then there's a central marking process nationally. And in the central marking process, then they select a couple of them that must then come to the national rounds of the program. So already from the school and the district and the province, you've really become successful people to be selected to come here. Then at the national rounds, they get an opportunity to battle it out in their oral rounds until we can get to the top two teams for the applicants and the respondents. What you see today is a culmination of that big ecosystem that has brought us here. So these are the top learners that have been identified through that very long process. Can we give them a round of applause? Let us now receive the keynote address from our Deputy Minister of Justice and Constitutional Development, Deputy Minister Adress. Don't worry, he's coming.
Very, very good morning to all. But I think our program director is maybe a bit incorrectly briefed, because I'm not here to make a keynote address, but to argue submissions before this court. May it please the court. I appear before this court on the instructions of Minister Mamuluku Kubai, the Minister of Justice and Constitutional Development, who conveys her very warm greetings. She is attending the funeral of the late Ambassador Nathi Mthethwa, who was also a very close comrade and friend of mine from the days of from our days in the ANC Youth League. But I thought that whilst ideally would have loved to have attended his funeral, the best tribute that I could pay to his life and struggle was to be here today. Council appears before this honourable court not against any party, but for a principle. The enduring truth that justice, like education, must be lived, tested, and renewed in every generation. The matter at hand concerns not the rights of appearance, but the appearance of rights themselves. The right of every young South African to see the Constitution reflected in their own lives and to see themselves reflected in the Constitution. This appearance, justices, is fittingly made before the highest court in our land, the Constitutional Court, where the architecture itself of glass, of brick, of light reminds us that transparency and truth are the pillars of a living constitutional democracy. I turn first to lay a factual background, the brief history of the Moot Court competition. The National Schools Moot Court competition was established in 2011. And I think instrumental to its establishment was the vision and the drive of the late Professor Christoph Heinz, who, with the assistance and the collaboration of former Deputy Minister of Education, Enver Surti, and if the court will indulge the submission, that of present counsel, who at the time was also Deputy Minister of Justice and Constitutional Development. It was born of a simple conviction that young people should not merely learn the Constitution as an academic exercise, but inhabit it as a lived experience. To test its meaning, to wrestle with its tensions, and to defend the ideals with both heart and with reason. 14 years later, the competition has grown into a national movement, a constitutional bar in training, producing not only future lawyers and judges, but teachers, activists, and servants of the people, including, I hope, future ministers and deputy ministers of justice. I'm advised, and I invite the bench to take judicial notice of the fact that this year a total of 180 teams entered the competition by submitting essays. Of these, 90 teams took place in the provincial rounds and 36 teams advanced to the national rounds. But I think the vision of those who started the Moot Court competition was never that of a tournament, but of a torch relay, with each generation lighting the way for the next in a long walk to justice. Justices, secondly, I turn and would like to make an explanatory submission on the question of robes. And I just want to say that for me it's particularly gratifying to, for the second time, be able to appear before this august court robed. I thought last year was going to be my first and only opportunity, but I'm very happy to be able to do so again. And I think it's important also just to point out that the robe is not a costume, but a covenant. Its history stretches back to medieval Europe, where scholars and jurists wore robes signifying learning, humility, and service. In South Africa, that heritage took on a new meaning after 1994, when Justices Albie Sachs and the late Justice Yvonne Mogoro redesigned the judicial robe in green to symbolize rebirth and transformation. The color green, drawn from our soil, represents renewal and rootedness. The red and black trimming, the lifebloods of criminal and civil law, and the unisex design, the equality of all before the law and upon the bench. And thus, when one robes, one puts aside self and puts on service. And if counsel may add with a smile, one also adds a touch of dignity that television dramas have yet to capture with accuracy. The robe reminds us that justice is not a garment of privilege, but a responsibility, stitched, as it were, with the threads of impartiality, fairness, and hope. Thirdly, Justices, I turn to the 2025 Moot Court statement. The case before, and which will be argued by counsel, my senior counsels. Earlier I came and offered my services as junior counsel, but it doesn't seem to have found much favor. The case of Thando Khumalo versus the Department of Basic Education and others raises a profound question, whether equality can be denied under the guise of language. Thando, a gifted 12-year-old from Eindhoven, was refused admission to her chosen schools, not for want of merit, but for want of language. The learners before us examined whether such an exclusion offended Section 9 of the Constitution, and whether the department's intervention respected both equality and the autonomy of schools. Their arguments reflect the deep and living tension of our democracy between institutional autonomy and equitable access, between individual right and the collective good. It was clear from the rounds that these learners did not simply repeat constitutional principles. They applied them with rigor, with nuance, and with empathy. Justices, fourthly, I turn to make certain submissions in support of constitutional literacy. We submit that competitions such as these are not mock trials, but are moral tutorials, constitutional laboratories where intellect meets conscience. In these chambers of learning, young advocates have sharpened not only their reasoning, but their sense of justice. They've learnt that argument is not noise, it is order seeking truth. We submit that whether they stood for the department or for the school, each one of you stood for the Constitution. And that's what makes all of you winners and victorious from the outset. The competition, therefore, fulfills a vital democratic function. It breeds constitutional awareness, empathy, and courage in a world that sorely needs all three. I turn then to make a submission on the right to education. The right to education, like the robe, is both a privilege and a burden, a duty owed to others and to the future. We acknowledge that in 30 years of democracy, our republic has made remarkable progress. More than 90% of young people remain in school, literacy rates are climbing, and the Bella Act has advanced multilingualism and accountability. Yet we cannot be content. The persistence of dropout rates, the uneven spread of resources, and the pressures on teachers remind us that the right to education remains a work in progress. But each challenge, justices, is an invitation to renew our commitment, a constitutional summons to act, not to despair. For education is not merely a policy goal, it is a promise renewed every morning in every classroom. We turn then to cite some authorities and precedent for our submissions. We draw firstly authority from the life and the work of the late Professor Christoph Heinz, who throughout his long and distinguished career as an academic really emphasized both in our country but on our continent the importance of human rights education as, in a sense, really a mother of all rights, because it does teach us what those rights are and, equally importantly, how to use them. Further authority lies in the precedent set by every learner who stood here this week, each one a living amicus curiae in the ongoing matter of South Africa versus despair and others. If this court has ever sought evidence that constitutional values are alive in the hearts of the young, Council respectfully submits that it need look no further than the arguments it will hear in this very hall. We then conclude with submitting certain acknowledgements. We acknowledge with gratitude a number of those without whom this constitutional dialogue would not flourish, and in particular, we would like to thank Chief Justice Mandisa Maya for very graciously agreeing to make this court available, and we thank Justice Collipin, Justice Musi, and the entire bench who have agreed to hear this matter. We thank the educators and mentors, the silent clerks of this great court who have prepared every learner to stand and speak with courage. We thank their parents for supporting them and making it possible for them to be here today. And we thank the South African Human Rights Commission and the officials of the Department of Justice and Constitutional Development for the invaluable role that they've played. So, we then turn lastly, justices, to the relief that we seek. We pray that this honorable court will enter into the record the following declaratory relief. Firstly, that the Constitution remains binding not only upon the organs of state, but upon the conscience of every citizen. Secondly, that every child, real or hypothetical, named or unnamed, including the symbolic Thando Khumalo, be assured equal access to opportunity so that they, in the very moving words of the preamble to our Constitution that we recited earlier, can also ensure that the full potential of each person is realized. And thirdly, that constitutional literacy continue to be advanced through initiatives such as this National Schools Moot Court competition, and that in this honorable court, hope be formally recorded as Exhibit A. In closing, we submit that while the robes may conceal individuality, they reveal humanity that we share beneath them, and that the Constitution lives not only on paper and precedent, but in practice, not only in this court, but in every classroom, courtroom, and community hall. To the learners, we say, you have already won, all of you. You've argued for justice in a time that the world sorely needs its advocates. The verdict of history will show that on this 12th day of October in the year 2025, you stood at the apex of our democracy and spoke with the authority of its founding promise. And so, if it pleases the court, counsel rests our case. I thank you.
Seeing that those remarks were directed to the bench, I have notes from all of the justices without exception that they have some questions for counsel. But we'll reserve that for a specially convened session.
We can call him for a particular commission of inquiry. Thank you so much, Deputy Minister. Spoken like a legal person. You can hear from his discourse that he knows this stuff. He's not a mere occupational therapist like me, who did inclusive education, those boring stuff, educational psychology. No, he does the real deal. I think at this point then, I'm going to give 3 minutes each to 2 learners who are just going to share with you, justices, about their experience of participating in this program. I'm firstly going to call on the podium Lisedi from Mpumalanga to just come and share. Only 3 minutes, Lisedi, and then after you, I'm going to call another one from Free State. Are you here?
Good morning, Your Honorable Court. My name is Lisedi Modise. My experience on Moot Court has been nothing but exceptional, filled with lots of learning stones and opportunities and experiences that I never thought I would ever experience. I've gained more than just legal knowledge. I've learned teamwork, discipline, and the importance of preparation. Moot Court taught me that success isn't about all the answers, but about how you respond when faced with difficult questions. I think I grew and I learned more confidence and how to speak in public settings. I feel more outspoken and I have learned how to express myself more. I met a lot of amazing people who have taught me different things in this experience. I got to experience the University of Pretoria, which was such an amazing experience, and I can't wait to share the different skills that I learned with everybody around me. Thank you.
Thank you so much, Lisedi. With yesterday being a day where we commemorated International Day of the Girl Child, and also looking at the experiences of girl children in South Africa and the vulnerabilities that they live with, I think we can all be proud of the empowerment that we are providing to children who are going through the education system in South Africa. Let's call the next one from Free State, Tumelo Majoro.
Good day, Honorable Justices. Hope you're having a good day. Well, my experience from Moot Court has been exceptional. Been a difficult journey, by the way, but it has taught me many things. Giving different communication skills, the way you can see how you can prepare and the way you can evaluate ways you speak, and how you can be able to present in front of respectable justices that will teach you the ways to elevate law and see your passion through it. Moot Court has been an experience that led us to see how the constitutional history has been built and how we can elevate through it. And Moot Court has taught us ways we can see, and if we want to pursue a law, that we can be respectable lawyers and be successful in our journey. Preparation is key, but also lessons that are learned in it make the journey joyful. And I'd like to say we have met many good people, many nice people in this journey who have taught us many things, how to communicate, how to talk to others, and how you can make other friends along the journey. I'd like to conclude my speech and say that's how Moot Court has put me here today, and the experience was nice, and it taught me many lessons. I thank you, everyone.
Thank you, Tumelo. Don't worry, 25th May every year is International Day of the Boy Child. And South Africa intends to submit to the United Nations for this day to also be recognized as an important day given the vulnerabilities and boys' disengagement in education. Without further ado then, I'm going to cease to exist, and I'm going to allow the justices and the teams that are here to do their thing. I'm going to hand over then to the bailiff to lead us through that. After that, once the panel of judges has heard from both teams, we'll be breaking then. I won't come back here. We'll be broken for lunch or whatever, or tea, whilst the deliberations will be happening in the background, and then I will come back here and reconvene everyone. Over to you.
All right. The court is now officially in session. We first be hearing from the applicant. When the applicant team finishes, we will then hear from the respondent. Honorable Judge.
Will counsel for the respective parties please place themselves on record?
As it may please the court, my justices, my name is Britemogelo Phakedi, and I'll be appearing on behalf of the...
Sorry. Just a bit slower. We want to get your name. What is your name?
Britemogelo Phakedi, Your Justice. B-O-I-T-E-M-O-G-E-L-O.
Here.
Surname Phakedi. P-H-A-K-E-D-I.
Thank you, Mr. Pakedi. And who appears with you?
As it may please the court, I would like for my co-counsel to come and introduce.
You can do that on their behalf. Okay.
We just need it.
Yeah, we just
need your name.
just the name for now. Okay. Would your co-counsel want to introduce herself? Okay, let's do that quickly then. Okay, let her do it. Thank you.
My co-counsel's name is Tsenopele Mofokeng. T-S-O-E-L-O-P-E-L-E.
Good. Thank you.
Do you need the surname, my justice?
Please.
M-O-F-O-K-E-N-G.
Mofokeng. Okay. Good.
As it may please the court. My justices, I'll be speaking for 10 minutes. My co-counsel will speak for 8 minutes, and we reserve 2 minutes for the rebuttals. I'll be addressing issue 1
Sorry, before you do that, we just want to get everybody else on record. You can take your seat. Who else appears then for the applicants? There are 2 teams for the applicants, correct? Oh, two speakers per team. Okay, sorry. So those are the 2 speakers. Thank you.
That's okay.
Okay, that's fine. Sorry.
If it pleases the court, I am Sandisiwe Nompecheni, and I am with my co-counsel, Johanna Moradi, and we appear before this court as the counsels for the respondents.
Sorry, I got your first name is Sandisiwe. What is your surname?
Nompecheni.
Ingomeshe. Would you spell it for us, please?
Oh, A N D I S I W E. Sandisiwe. Surname
Sandisiwe.
is N O M P E T S E N I. Nompecheni. And my co-counsel is Johanna Moradi.
Joanna, surname?
Maredi.
Malete.
Yes.
Maredi.
Yes.
Okay, thank you. Okay, just before we start, I just want to appeal to you. I think you're probably a bit nervous. You're speaking a bit fast. We're battling to get your names as well, so please relax. The purpose of today is not to trick you or to show you how clever we are as judges. It's really to listen to you and to listen to your arguments. So take a deep breath, have a sip of water, and when you are ready, Mr. Pakedi, we will... Are you? Okay, good. Madam, will you be keeping the time? Okay, thank you. Right.
My justices, I'll be speaking for 10 minutes. My co-counsel will speak for 8 minutes, and we reserve 2 minutes for the rebuttals. I'll be dealing with issue 1 before this honorable court, whether clauses 4 and 5 of Zebra and Belda's admission and language policies are unconstitutional under Section 9 of the Constitution. And along with that, I'll be dealing with Section 9 of the Constitution. My co-counsel will be dealing with the second issue regarding the HOD directive and whether they are lawful under Section 38 My justices, let me begin by saying this is not a case about punishing schools for choosing Afrikaans. This is not even about one language versus another. This is simply about a 12-year-old girl, Thando Khumalo, who's been told, oh, there's a seat for you, but not if you speak isiZulu. A girl who lives in the federal zone of 2 excellent high schools, who has the marks, the ability, and the talent, but who is denied access based on the language she speaks. My justices, this isn't just that breaking, it's unconstitutional. My justices, I believe that's where the law must be. Section 9 of the Constitution, the right to equality prohibits not only direct discrimination, but indirect discrimination too. And this is exactly that. These policies don't say we exclude black children or exclude isiZulu speakers, but my justices, when a school in a multilingual and a multicultural town says only those who are Africans' home language may be admitted, it may result in exclusion that falls overwhelmingly on learners who are from historically disadvantaged backgrounds. My justices, in the Huxon v. Lane case, there was a 3-stage test that was conducted in order to determine if there is unfair discrimination, and I'll be applying that 3-stage test in my case. The test proceeds in the following stages. Firstly, is there differentiation? If so, we move to the second stage, where we will determine if the differentiation is on a listed or a prohibited ground, and if so, we proceed to the third stage, where we will be proving the rationality of the discrimination. My justices, in short, the policies of the school are neutral in language, but they are discriminatory in effect. And I'll be proving this through the Huxon v. Lane case, which deals with the equality clause under Section 8 of the interim Constitution, and whose analysis is similarly reflected in Section 9 of our Constitution. My justices, now I will get into stage 1 of the Huxon v. Lane case test. Firstly, is there differentiation? My justices, in this case, the clauses differentiate by treating learners unequally based on home language or Afrikaans fluency, denying admission to those who are non-African speaking, while they are limiting admission to those who qualify linguistically. And as highlighted in the Huxon at paragraph 43. My justices, this impacts the core rights. For example, Section 29 subsection 1's right to accessible, basic, and further education, and Section 28 subsection 2, which states that the best interests of the child are of paramount importance in all matters concerning the child. My justices, with proving that there is differentiation, I would like to get into stage 2 of the test, where I will be giving out to the court if the differentiation is on a prohibited or on a listed ground. My justices, in this case, there are grounds of differentiation, as language is a specified ground under Section 9, subsection 3, intertwined with culture, ethnic, social vision, and even historical disadvantage. For example, the apartheid's elevation of Africans in white schools to exclude black African languages like isiZulu, as highlighted in the Haxon at paragraph 46. My justices, objectively, the policy bars isiZulu and English-speaking learners from Eindhoven's diverse multilingual community, now with growing isiZulu populations, despite their proximity and their suitability. For example, in this case, Thando Khumalo, a top-achieving learner, would make an ideal and an excellent student in these schools. And this shows that there's no mere differentiation that is being exercised in this case, but it is targeted exclusion, as highlighted in the Haxon at paragraph 44. My justices, with proving that there is differentiation and it is on a listed ground, I would like to get into stage 3 of the Haxon B-link test. Firstly, is there a rational connection? In this case, even preliminarily, the differentiation lacks a rational link to a legitimate purpose. Maintaining single medium African schools may serve the existing learners, but my justices, excluding 202 federal area applicants, ignores the Schools Act's requirement for policies to be able to reflect on the needs of the broader community, such as changing demographics, equity, and equality. My justices, Eindhoven's vibrant youth culture and diversification render the policies as arbitrary, not serving the common good, as highlighted in the Haxon at paragraph 43. My justices, with English schools full and alternatives 10 kilometers away, this frustrates access without justification. As differentiation on a specified ground, it precipitously constitutes unfair discrimination under Section 9, subsection 5 of the Constitution. My justices, I would like to touch on the impact and dignity and systematic disadvantages. In this case, the exclusion that is being exercised stigmatizes non-African speakers as outsiders, denying Thando, a 12-year-old girl from a historically underserved community, isiZulu community, her preferred high-quality education. My justice, this reinforces apartheid legacies where language policies entrenched on racial exclusion. And that's why I would like the court to also weigh Section 29, subsection 2C, which is the need to redress past discriminatory laws. My justices, this was highlighted in the head of department in Mpumalanga, Department of Education versus World School MLO 2010 at paragraph 76. My justices...
Could I interrupt you and over here and ask you on the question of discrimination? It seems that the law tries to strike a balance between, on the one hand, giving to governing bodies certain powers to determine language policy, and on the other hand, to ensure that those policies are in line with the Constitution. In your view, how does one strike a balance between these possibly competing considerations?
As it may please the court, my justices, counsel for the applicants submit that we are simply not against African medium schools, but we are only asking the schools that use policies in order to exercise exclusion, to be able to adopt the learners who need education and this is constitutional in line with our constitution. My justices?
Yes, but Mr. Kabindi, your case is that sections 4 and 5 of the school admissions policy are unconstitutional. Is that correct? That's what you're arguing.
My justices, my justice, as it may please the court, I would like for you to repeat the question.
You're attacking sections 4 and 5 of the admissions policy, are you? You're saying those are unconstitutional. Is that right?
As counsel for the applicants, we respectfully submit before the court that Section 5, subsection 5, and Section 6, subsection 2 of the Schools Act, yes, they do entrust admission and language policies to the...
Yes, I'm sorry, that wasn't my question. You said that, as I understood your opening remarks, you were saying that you were going to address us on the constitutional validity of sections 4 and 5 of the admissions policy. Do I have that wrong? Did you not say that?
My justice, I would like for you to repeat the question.
Did you not say in your opening submissions that you were going to address us on the constitutional validity of sections 4 and 5 of the admissions policy?
As counsel for the applicants, My Justice, I did not mention that.
You didn't say that. Oh, I must have made a mistake then. Do you say that, is your submission then that that a single medium school is by necessity unconstitutional? What's your submission on that? It's perfectly constitutional, isn't it, for a school to say, we're an Afrikaans medium school, we're an isiZulu medium school, we're an English medium school, and we want to teach only in that language. Do you say that's unconstitutional?
Counsel for the applicants submitted, we are saying that it is unconstitutional for learners to be getting education based on the language that they speak, despite their suitability to go into the school. My Justices, to finish off my argument, I would like to touch on the position of the complaints. As children from diverse, historically marginalized groups in a transforming town.
Your time is up, but we will allow you about 3 minutes to pull together your arguments. Thank you.
My Justices, in this case, these learners are disadvantaged relative to African speakers. The policies ignore Section 28, subsection 2's paramountcy of best interest of the child and Section 29, subsection 1's right to accessible, basic, and further education. And this was highlighted in the governing body of the Juma Masjid Primary School versus the SA and at paragraph 66 to paragraph 68. Counsel for the applicants, I respectfully submitted. As it may please the court, I would like to step down and hand over to my co-counsel.
Mr. Psikedi, before you take your seat, Section 29(2) talks about a right to education in the language of your choice. But it's qualified because it says where that education is reasonably practicable. How does that qualification influence your argument, if at all? Context of the school that Tanda wants to go to.
My Justices, counsel for the applicants, we submit that in this case, it might seem like it is not practicable, but as it was stated that the schools have limited space so that they can be able to accommodate the learners, and if they lack anything that they need in order to give out education to these learners, the HOD will have to provide the resources that they need. As it may please the court, I would like to take my leave.
Just ask one last question, follow up. So if I follow your reasoning, which seems to be based on Harkson, and we accept that there is differentiation due to language, then why is there not a rational connection into what the school is doing?
As counsel for the applicants, my Justice, we respectfully submit before this court that the rational connection between us limiting the rights of the learners who are existing at the schools is that they can be equal in sense of they will all be getting education in their own town. And the schools are not doing that because the schools are simply blocking other learners who do not have alternatives to go to so that they cannot get education, access to education. As it may please the court, I would like to take my leave.
Seems like, okay, you want to take your seat. Thank you. Good. Thank you. Ms. Mafokeng? Serious? Mr. Mafokeng, sorry. Mr. Mafokeng, you have 8 minutes to deal with the second issue, correct?
Yes, Your Justice.
Thank you. You may proceed.
May it please the court? Since we have already determined that Tando Kumalo and the 201 other learners have been unfairly discriminated against, we can argue that the HOD's directives are not unlawful and do not violate the existing learners section 28.2 and 29.2 constitutional rights. My first argument resides around the section 28.2. When the HOD instructed the SGBs of Zebra and Veld I schools to add English as a second medium of instruction, she did not say that Afrikaans would be excluded, only that English was to be added too. This Section 28.2 states that the best interest of the child are of paramount importance in any matter concerning the child. This principle guides the courts and authorities in making decisions that affect children. This principle also proves that Thando Khumalo and the 201 other learners' best interests have not been taken into account. I'd like to bring the court's attention to, in S versus M, the court described Section 28.2 as a binding obligation on the decision makers and not just a symbolic aspiration. This deems the schools to not only apply the law to the already existing learners within the schools, but also to Thando Khumalo and the 201 other learners because they have fallen into the school scope. By implementing English as a second medium of instruction and admitting Thando Khumalo and the 201 other learners, not only will we be giving Thando Khumalo and the 201 other learners as rights, the ability to compete with the rights of the already existing learners within the schools, but we will also be completely enforcing the law. When the HOD instructed English to be added, she was considering the fact that Thando and the 201 other learners will be left with no education whatsoever. And I'd also like to bring it to the court's attention that she did acknowledge the fact that the already existing learners within the school will still be receiving education within their language of choice, showing that she actually considered the educational needs of all the children who are involved within the case of Thando Khumalo. I'd also like to show the court how the schools have been in clear violation of Section 5.6 of the South African Schools Act 84 of 1996, which states that the governing body of a public school, when determining the language policies or the amendment thereof, must be, in order for them to be satisfied with the policy or the amendment thereof, it must take into account the language needs of the general and broader community in the educational district in which the school is situated. The school has not been doing this since the English and Zulu community has since been growing. In Section 5F of the South African Schools Act, which involves the enrollment trends of the schools have clearly not been taking into account the enrollment trends, as so many Zulu and English-speaking learners have been applying to these schools but have been denied admission. In Section 6.6 of the South African Schools Act, the SGBs of the schools are mandated to review their language policies every 3 years or at the request of the HOD. These schools have clearly not been reviewing their language policies because if they had done so, they would have had English and Zulu as additional languages within the school a long time ago because circumstances require them to. And I'd also love to bring you to the court's attention that the HOD did request the SGBs of the school to review their language policies, but their request was denied. Furthermore, in Section 5A of the South African Schools Act, which speaks to the best interest of the child, with emphasis on equality as stated in Section 9 of the Constitution, 201 learners, including Thando Khumalo, will be left without any education whatsoever because these two schools, which are in their feeder area, refuse to accept them, thus clearly showing that the schools did not take into account the best interest of these children. Section 36, my next argument will be residing around the Section 36. We accept the fact that we are limiting the educational scope of the school, but it is justifiable. In Section 36 of the Constitution, it provides that we are able to limit any laws as so long we do not violate it. But there are 5 elements that we need to take into consideration when limiting a law. The nature of the right, the importance and the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose, and the less restrictive means to achieve this purpose. How this applies to our submissions is the nature of the right. Equality is core, but is minimally limited. In purpose, cultural purpose is important, but is outweighed by equity in such a diverse community like Edenhoven. Extent and relation. Overboard exclusion lacks connection to effective education, and this burdens the applicants extensively. Other alternatives. Less restrictive means is to add English as second medium of instruction as the HOD has directed. In high school, Ermelo and others versus Head of Department in Mpumalanga Education, 2007, this case deals with the limitations clause. In a similar case to this one of Thando Khumalo, where it states that every learner has the right to basic education. In the case of Thando, we need to give their rights the ability to compete with the rights of the already existing learners within the schools. Therefore, we see it fit to limit the comprehensive and the overly diverse curriculum that the learners within the existing schools are receiving to basic education if this means that Thando and the 201 other learners will be receiving education. Counsel for the applicant humbly requests...
Mr. Mofo, can I ask you this? The schools say that they don't have the capacity to take on board the additional 101 learners. Let's assume that at least at the factual level, that is correct. Is that a factor this court should take into account in determining the lawfulness of the directions given by the HOD?
Thank you so much for that question, Your Justice. In fact, the schools are not to full capacity yet and still have space to admit Thando Khumalo and the 201 other learners. The only thing binding them is this language policy, Your Justice. Firstly, we would like the Supreme Constitutional Court to
Mr. Mofokeng, if we take that at face value, if we take the fact that they say they don't have the capacity at face value, isn't there a problem with the fact that there are 4 other Afrikaans medium schools in Eindhoven that the MEC didn't investigate? Isn't that a further problem with the decision?
Your Justice, when presenting a case similar to this one of Thando Khumalo's, it should start somewhere. The vibrancy should begin at some point. So therefore, the HOD could not just consistently attack all the other schools, but needs to phase in the idea through Zebra and Veld High schools. We'd like the Constitutional Court to overturn the rulings of the High and Supreme Court, affirming that firstly, clauses 4 and 5 of the school's ambition and language policies violate the applicant's right to equality as stated in Section 9 of the Constitution of South Africa, and that secondly, the HOD's directives are lawful and do not violate the existing learners' Section 28.2 and 29.2 constitutional rights, and that the directive to add English as a second medium of instruction within Veld and Zebra High schools will be enforced. And if I am of no further assistance to the court, may I please take my leave?
Thank you, Mr. Mofokeng. Can we hear from the respondents then?
As it pleases the court, I am Sandisiwe Nompecheni and I am with my co-counsel Johannesburg, and we appear before this court as the counsels for the respondents. Now, me and my co-counsel will be utilizing 10 minutes each of the given time by the court. Now, I, as the first speaker, will be arguing on the first issue, which is clauses 4 and 5 of the school's admission and language policies do not violate the right to equality under Section 9 of the Constitution and are not unconstitutional. And my co-counsel will be arguing on the second issue, which is the directives issued by the HOD violate the rights of the existing learners under Section 29, subsection 2, and Section 28, subsection 2 of the Constitution. Now, the respondents oppose the constitutional values brought by Thando Khumalo, the Minister of Basic Education, the MEC, and the HOD. Now, we argue that clauses 4 and 5 of the school's admission and language policies are not unconstitutional, and that the directives issued by the HOD are unlawful, unreasonable, and are inconsistent with the rights of the existing learners under the Constitution. Now, clauses 4 and 5 do not violate the right to equality under Section 9, because now clauses 4 and 5 of the school's admission and language policies require that a learner must either speak Afrikaans as a home language or be fluent in Afrikaans in order to be admitted. Now, this is based on educational and linguistic practicality, not race, ethnicity, or social background. And also Section 9 of the Constitution guarantees equality before the law and also prohibits unfair discrimination. However, not all differentiation amounts to discrimination. And now this court in Case Law versus Vendal has that differentiation discrimination is, and now this court in Case Law versus Vendal has that differentiation is permissible, and also in Taxi the Survey, this court explained that for a policy to violate Section 9, it must be discriminatory and unfair. We submit that there was no unfair discrimination that was done upon these rules. However, it was differentiation on the basis of language, and it was fair because now there was an equal distribution of that on the basis of language. Now, we wish to refer this court to this court held that not all differentiation amounts to unfair discrimination, and that differentiation becomes unfair only when it is irrational or impairs the fundamental dignity of those affected. This ensures that learners admitted to Zebra High and Veld High School can participate meaningfully in instruction which exclusively delivers in Afrikaans. Now, language is not used here to exclude unfairly, however, to implement language policies designed to ensure effective functioning of the schools, especially if the schools operate primarily in a particular language. For example, Your Justices, if a school teaches in Afrikaans and does not have sufficient resources or teachers to accommodate additional learners, then limiting admission on this basis may be an administrative or educational decision, not one meant to discriminate. Now, this is similar.
Can I just ask you this question? You say that if differentiation results in the impairment of the dignity of somebody, then that differentiation would constitute discrimination. Is that your argument?
Thank you, Joseph, for the question. We're saying that a differentiation is unfair only if the justice only if it serves a legitimate purpose and only if it serves a legitimate purpose and implemented fairly, Your Justice.
So just repeat the last part. Only if it serves a legitimate purpose and
it is implemented unfairly, Your Justice.
It is implemented unfairly.
Yes.
Okay, sorry.
Thank you, Your Justice. Now, Your Justice. Now we are saying that language is not used here to exclude unfairly. However, to implement language policies designed to ensure effective education, especially if effective functioning of the school, especially if the schools operate primarily in a particular language. Now, for example, Justice, if a school if a school teaches in Afrikaans and does not have sufficient resources or teachers to accommodate additional learners, then limiting admission on this basis can be an administrative or educational decision, not one meant to discriminate. Now, Your Justice, this is similar to the case.
Can I ask you a question? If, when the school was established, the predominant population in the area that served the school spoke Afrikaans, the school gives instruction in Afrikaans. That's the reason why everybody who comes speaks Afrikaans. That's the original basis for the establishment of the policy. Let's accept that for purposes of the case. But with the changing demographic within the town and within the area, the school has place now. It doesn't have enough students who are Afrikaans speaking to properly utilize the facilities that are available. But it has students who don't meet the language policy, who can now occupy the school. On what basis can one then draw a line in the sand and say, well, historically, this was the language we started with, and at all costs we must now
that this schools uses Afrikaans as a medium of instruction. Now we must acknowledge that if Eindhoven is a diverse town, and also now these schools, there are 12 schools in the town of Eindhoven. 6 other schools uses Afrikaans as a medium of instruction, and 6 other ones use English as a medium of instruction. So now Your Justice, since now Eindhoven is a multilingual town, but however, English and Afrikaans are the most dominated languages. So now those who speak Afrikaans are compelled to be admitted in the school that uses Afrikaans as a medium of instruction, and those that use English are compelled to be admitted in the school that uses English as a medium of instruction, Your Justice.
Doesn't that just replicate the injustice of apartheid? I mean, the problem with this admissions policy is its inflexibility. You've defended it on the basis of practicality, but the policy doesn't say anything about practicality, does it? It just says we're an Afrikaans school, and if you don't speak Afrikaans, go somewhere else. Isn't the problem the inflexibility of the policy? It doesn't say anything about if we have capacity, we'll consider English-speaking students. It just says we're an Afrikaans-speaking school, and that's the end of it. Doesn't that render the policy unlawful?
Now, thank you, Your Justice, for the question. Now, Your Justice, it is mentioned in the promise statement that Veld High Schools and Veld High Schools and Zebra High School, yes, they have space to admit those learners. However, they said that they have few space, Your Justice. And now when it comes to the practicality, Your Justice, now if we are forcing these schools to admit English learners without preparation, without funding, Your Justice, it is not reasonably practicable.
You're representing you're arguing about the policy on its face, aren't you? You're not, as I understand in this section of your argument, attacking the ME or defending the MEC or attacking the MEC's decision. You're saying this policy on its face is constitutionally valid.
Yes, it just.
And given the fact that this policy doesn't mention any of the practicalities that you say it's based on, and doesn't admit of any limitations based on those practicalities and any possibility of flexibility based on those practicalities, that's a problem, isn't it?
I do not think that I understand your justice. Will you please rephrase it?
I'm probably just gratuitously repeating my first question, so I think I'll just leave it there. Thank you for your answer.
Yes, thank you, Your Justice. Now, Your Justice, language policy in question applied to all learners equally regardless of their race. Now, they serve the legitimate purpose of maintaining the schools functioning as Afrikaans medium of instruction, which is a right recognized in Section 29, subsection 2 of the Constitution. Now, Afrikaans is a constitutionally recognized language, and also the use of Afrikaans as a medium of instruction ensures that learners receive education in a language that they understand. Now, the policy is reasonable, and aimed at preserving effective education. And also, the schools are not acting out of prejudice, but in line with their identity, capacity, and also the community needs. Now, the town of Endervon already has 6 medium public high schools, and the fact that these are full does not mean that English public high schools, Afrikaans meet English public high schools must change their core functioning. And also, a lack of space elsewhere does not render a language policy unconstitutional, especially when that policy is uninformedly applied or educationally justified. Now, in paragraph 5 of the problem statement, it is stated that Tando applied to Zebra High and Veld High schools because those were her schools of choice. However, the right to basic education doesn't entitle one to attend the schools of their choices, as our court have made it clear in Rovenia Primary School versus MEC for Education in Gauteng Province that doesn't necessarily entitle a learner to education at the public schools of their choice. In a similar vein, the court ruled in whole school overall that the right to education doesn't mean to be admitted into a particular school, rather in an appropriate one where education can be reasonably provided, and this ensures fairness to both the schools and the learners. And under Section 29, subsection 2 of the Constitution, everyone has a right to receive education in their own official language, if were reasonably practicable. And now, forcing these 2 schools to adopt English as a second medium of instruction without adequate preparation, funding, or support is not reasonably practicable. And teachers that are trained to teach in Afrikaans may not be able to teach effectively in English. Now, according to subsection 2 of the South African Schools Act, number 84 of 1996, the school governing body has the power to determine the language policy of the schools, subject to the Constitution. Now, the language policy requiring Afrikaans as a medium of instruction is lawfully adopted and not arbitrary. Now, it reflects the cultural and linguistic rights, section 30 and 31, which include the right of communities to maintain instruction as their language of choice. Now, schools with limited resources cannot be compelled to accommodate additional learners if that would require a complete change in the medium of instruction, infrastructure, or additional staff. Now, if the court pleases, I would like to speak to my co-counsel to finish up the rest of the session.
Can you speak a bit louder? See if you can pull the mic closer to you.
As it pleases the court, I am Johanna Maredi, the second counsel on behalf of the respondents, the SGPs of the schools, namely Zebra and Veld High Schools and the Coalition of Concerned SGPs. I will be speaking for 10 minutes, but firstly, I would like to review the applicant's arguments. Applicants state that the 2 schools, which are Zebra and Veld High, ignored the 202 applicants from getting education at a school of their choice. But we respondents submit that Zebra and Veld High are not the only schools in Eindhoven. The children can go to the rest of the schools. Therefore, the applicants are the two schools, not considering the other schools. If they really wanted to ensure equity and fairness, their directive should have been exercised to the rest of the schools in Eindhoven. Also, the applicants also stated that Zebra or VELD should have implemented English if they reviewed their policies and on behalf of Zulu and English-speaking students. But we respondents submit that among the 202 students, not every student is probably English or a Zulu speaker. So the ethnicities are not considered according to the applicants, which contradicts the section 28, subsection 2 of the Constitution. Therefore, I would like to state my 3 issues. Issue number 1 is whether the HOD's directives are unlawful and unconstitutional, violating the existing learners' rights under section 28, subsection 2 and 29, subsection 2 of the Constitution. I will also expand on the legitimacy of these policies under sections 3 of the South African Schools Act 1984 of 1996, the section 36 of the Constitution of the Republic of South Africa. Before proceeding with my submissions, the respondents would like to inquire whether the justices would prefer a brief summary of the facts or whether your justices are well acquainted with the facts.
I think you can take it that the justices are diligent, that they've read the facts, so you need not focus on the facts. We know the facts. But it's your time and you can decide how you want to use it.
Thank you, Your Justice. The respondents submit that this case concerns 2 schools, which are Zebra and VELD High Schools, the 2 long-standing institutions established to serve the Afrikaans communities in Eindhoven. For decades, these schools have...
Are you going through the facts now?
Yes.
You don't need to.
Oh, thank you, Your Justice.
I would say you rather use your time to present your arguments. That might be better use of your time.
Thank you, Your Justice. If it pleases the court, I would like to proceed to my first submission, which talks about the unconstitutional and unlawful HOD's directives. The respondents submit that the directives issued by the HOD are procedurally and substantially flawed. In terms of Section 6, subsection 7 of the South African Schools Act, the HOD may not only direct a school's language of instruction where reasonably practicable to do so, and subject to the factors listed on Section 6, subsection 5, including available resources, classroom space, and the best interests of the children are paramount as per Section 28, subsection 2. No evidence have been presented to show that Zebra and VELD High have the capacity, whether in staffing or infrastructure or materials, to ensure and accommodate 202 extra students and deliver English medium instruction without compromising the quality of education for existing learners. The directive bypassed the Constitution with the SGBs and failed to account for the impact on current learners, violating both requirements of the constitutional principle of participatory government. I would like to proceed with the second submission, if the court pleases, talking about...
Let's ask this question, please. You say that the directive was confined to these 2 schools.
Yes.
And didn't cover the others.
Yes.
But on the facts that we have, these schools fall within the feeder area in which Tando lives, correct?
Yes.
And the 201 learners who seek access to schools also live within these feeder areas.
Yes.
So at least on the facts, we don't know if the problem exists in the areas covered by the 4 other schools, but we know that the problem exists. Yeah, correct. So what is wrong in the HOD confining the directive to these 2 schools?
Thank you, Your Justice. Well, it is stated in the problem statement that the other nearby school is also there, which can accommodate Tando and the other students. Why isn't the directive passed to the exact school, which is 10 kilometers away? It is also included as it's also in the feeder area.
Not part of government policy that you should try and accommodate learners who live within the feeder area of a school where it is reasonably practicable to do so?
We may or may not accommodate the students because our policies have been reviewed and it is stated that we only admit African-speaking students unless the HOD had already implemented fees and reasonable resources to fund us and so learners can be admitted into the schools. But without those, without infrastructure, the needed teachers to help these students, therefore we cannot accommodate all these students at once because our capacity, our resources are limited to the already enrolled African students.
Ma'am, if one takes a broad view of the rights of the learners for the entire town, and the point is made in the fact statement that if Thando and the other learners are admitted to the two schools concerned, it's going to have an adverse impact on the education of those that are already there. Is it possible to make an assessment as the HOD did without taking into account all the other schools? I think this is it's an adjunct or follow-on to the question posed by Justice Collipin. Surely the HOD had to look at all the schools and see the position of all the learners and all the resources that were available before making a decision on whether or not it was appropriate to issue the directives for the specific schools.
Thank you.
To that?
Thank you, Your Justice. Well, the HOD could have considered making a research on all the other schools in Eindhoven, as much as she or he didn't make consideration or investigations both in Zebra and Veld High. Well, therefore, if the HOD had done that, we would see or we would be already making policies to implement it to consider accommodating the other students in the schools. But because the HOD skipped that stage of considering of investigating, therefore we can't admit the students also.
But was the MEC required to take that into account? The statute says it has to be reasonably practicable for these two schools to take on these particular students. If these schools can reasonably, practicably take on these students, what difference does it make that other schools outside the feeder area might also be in that position?
Well, thank you, Your Justice. Considering that the entire town is in Eindhoven, to ensure equality and fairness, each of the schools had to have the directive issued out by the HOD to ensure fairness. The difference here is that this HOD is specifically targeted Veld and Zebra high schools without taking into considerations that there are other schools. Zebra and Veld High cannot be compelled to take students beyond their capacity. Thank you, Your Justice. Therefore, I would like to proceed with my second submission, if the court pleases, talking about how the language...
Probably have about 2 or 3 minutes left.
Thank you, Justice.
Well, you have 1 minute left officially, but we'll add another 2 to that, okay?
Thank you, Justice.
Because we've been engaging you a bit more vigorously.
Thank you, Justice.
We've withstood so far.
In the terms of Section 3 of South African Schools Act, the state bears the responsibility to ensure that every learner is able to develop their full potential. Zebra and Veld High School have been fulfilling this mandate by maintaining high academic standards through Afrikaans medium of instruction. Afrikaans is not merely a language of instruction, it is a foundation of the schools. It is a foundation of the school's pedagogical model, curriculum delivery, and the institutional coherence. The language policy is therefore not exclusionary, but a standard mechanism to uphold the educational excellence and continuity. And if it pleases the court, I would now like to proceed with my last and final submission, which addresses the constitutional permissibility of limiting the applicant's rights under Section 36 of the Constitution. Section 36, subsection 1 provides that rights in the Bill of Rights may be limited by a law of general application provided, such as limitation is limited A limitation is reasonable and justifiable in an open and democratic society. This assessment must consider the nature of the right, the importance of the purpose of the limitation, and the existence of less restrictive measures to achieve that purpose. The language policies of Zebra and Veld High School constitute a lawful and proportional limitation not aimed at exclusion. Similarly, in micro-primary school versus Western Cape Department of Education in 2005, the court held that the school's decision to maintain Afrikaans as a language of instruction was valid, where the schools lacked the resources to offer dual medium instruction. The same principle applies here. Zebra and Veld do not have infrastructure or qualified bilingual teachers to implement dual medium teaching without compromising academic standards. In conclusion, Your Honorable Justices, the Respondents' Council submit that while the right to basic education under Section 29, subsection 1, paragraph A is immediate, its implementation must not come at any expense of the equally protected rights of other learners. The HOD's action fails to balance these interests and thus constitutes an unjustifiable administrative overreach. In conclusion, the language policies of Zebra and Veld serve a legitimate and constitutionally recognized purpose. Therefore, we pray to this court that the council to declare the clauses 4 and 5 of the Zebra and Veld High School's admission policies are constitutionally valid. To declare that directives issued by... Oh, my time has...
Finish your sentence. Finish your sentence.
To declare the directives issued by the HOD violate the rights in Section 28, subsection 2, and Section 29, subsection 2 of the Constitution. Lastly, that the applicants bear the cost of
the
this...
next sentence now, but you're taking a chance. That's fine. But finish that, lastly.
Lastly, that the applicants bear the cost of this application on the basis that the respondents acted reasonably within their statutory and constitutional mandate. And it pleases this court, I would like to take my leave.
You want cost as well, eh?
Yes.
Tough. Thank you, Ms. Maredi.
Thank you.
Who's going to submit the reply on behalf of the applicants? 3 minutes. That's Mr. Mofokeng. Thank you.
May it please the court. Before resuming your justices, I'd just like to touch on a point that I heard you mention about costs. If for any reason our directive does fail, we aren't able to be cost because we were acting in the best interest of the children. We were acting in the best interest of the children and we were not really trying to hurt anyone. Firstly, they have established the fact. Is
there a case that you can cite that will help us in not awarding costs against you if we are not with you?
Not at the current moment, Your Justice.
You can perhaps do. Okay.
Thank you, Your Justice. They've established the fact that that the school is meant to serve this Afrikaans community, and we back it up with Section 6.5 of the South African Schools Act. But the main issue there is that they subjectively apply the law to the extent where the Zulu and the English community has been growing, but they fail to cater for them. The respondents are fleeing from their mandate equally to how the schools are fleeing from admitting Tandon the 201 other learners as they're supposed to. The main flaw on their side is that they attempt to defend the language policies of the schools, but the language policies of the schools are not being infringed by in any way. The learners who are already existing within the schools are still going to be receiving a basic education within their language of choice.
Okay.
Yes, Your Justice.
They say that the Department of Education has targeted these two schools. There are 4 other Afrikaans medium schools that have not been investigated at all. And they say, well, that is a flaw in the department's investigations. What do you say about that?
Justification for that, Your Justice, is that these two schools are in Thando Khumalo's feeder area and therefore were the ones to be engaged with firstly. They acknowledge the fact that the other schools are to capacity, which means that it would be difficult for them to have to cater for more. They acknowledge that the other schools are to capacity, which means that it would be difficult for them to have to cater for more. But they're ignoring the fact that the Afrikaans learners within the schools are not only receiving a comprehensive curriculum, but are receiving it to the point where they still have leftover space. Therefore, we see it fair to allow Thando Khumalo's rights and the 201 other learners, give them the ability to receive education, which at the current moment, they're not at all because these two schools, which are in their feeder area, denied them admission. And correction to what our learned friends here have expressed, we will be allocating English teachers to the school and not forcing the Afrikaans teachers to teach English as well. And if I'm of no further assistance to the court, I'd like to take my leave.
Mr. Mufokeng,
Yes, Your Justice.
they also complain about the issue of capacity and infrastructure. What is your take to that?
On the issue of capacity and infrastructure, we see it better to cater for these children within Veld and Zebra high schools because the other schools are not only to full capacity, but to what extent are we supposed to continue adding to those schools before we make a change that will equitably be able to cater for more Zulu and English-speaking learners after Thando Khumalo and the 201 learners who are currently wanting to be admitted within the schools.
That concludes the oral submissions. The court will adjourn for approximately 10 minutes, and then we will return to deliver our verdict in the matter. Thank you.
Thank you, Justice.
Gents?
I am told that the judges will require about 15 to 20 minutes of deliberation, so you can stretch your legs, get something to drink, run to the loo, come back at that time. Thank you.
next?
to do this. So congratulations to all of you. And those who's not the oralist of the day or who's not the team of the day, please don't take that negatively. And I want to say to those of you who didn't get an opportunity to argue today, or those of you who have come along in the provinces, you must have been very good for these people to now be the finalists. So take that with you. There's no winners, there's no losers, it's an opportunity. And when you go away from here, please talk about the Constitution. Try and apply it. Even if you don't become a lawyer, you can always go into the Department of Justice and from the inside fight. You can become a lecturer, you can go to an NGO, or you can do anything else. But please let the Constitution go down to the roots, and you are the people that can do that. So it was a joy being in front of so many young people this morning, although I am now hungry. But it was an absolute joy, and congratulations to all of you.
Yes, I would like to add to what my sister has just said now. It's an honor for me to have attended this, and I feel you know, what I saw today, it's so amazing. If one looks at your age, at my age, it's true I wouldn't have been able to do what you have done. You have been so excellent, and those of you who didn't make oral submissions, you learn from what you hear us saying, and then when you go back, you look at where one could have made the mistakes, and then with those who have presented, you know, there was a lot of speed. It's always wise to listen to yourself when you talk. Take time, you just relax, and then listen, talk, hear yourself, and then you'll be able to deliver. Congratulations to all of you. Thank you.
Yes, I think my sisters have covered me. Congratulations to all of you. I think there's a gentleman who made a word, said something and started. I forgot his name. He said, the idea is not to win, it's to participate. And by you all being here, you are all winners. Congratulations. Thank you.
The best public speaking advice I ever received was, if you think you're speaking too slowly, speak slower. If you take one piece of advice away today, take away the advice about pace. Time is not going by as quickly as you think it is. Some of us have stood there and made submissions. It is a terrifying experience, and it doesn't get any less terrifying if you do it more than once. We understand that. So you need to take a breath and understand that time is passing for you faster than it is for everybody else. And if you take a breath, if you leave a pause, and if you speak a little bit more slowly, nobody's going to worry about it. In fact, they're going to thank you. So if you think you're speaking too slowly, speak slower. Congratulations to you all. I did my first Moot when I was in university. You were way better than I was. My Moot was a total disaster, and I'm very glad that there were no cameras around when I did it. But you really were fabulous. I enjoyed your submissions enormously. I listened very carefully to them. I also tried to engage with them, and that's the second bit of advice I want to give you. Advocacy is about establishing a dialogue with the presiding officer. You will not persuade anyone unless you can engage them in conversation. Once you're engaging someone in conversation, you have the best chance possible of persuading them of what you want them to accept. And that involves speaking, listening, and answering. So if you're going to take this up as a career, if you're going to try and get a little bit better, and that's the point of all of this, it isn't to be perfect, it's to just to get a little bit better. Remember, as beautiful as you think your speech is, and your speeches were beautiful, all of them, leave space for engagement and conversation, because that's where you persuade. Congratulations to you all. You've all done fabulously well.
Yes, I was going to take the easy way out and say I concur. But from my side, I just also want to commend all of the participants today. You clearly put in a lot of time and effort into it. And if nothing else, you would have learned from this that there are no alternatives to hard work. There are no shortcuts. And preparation is key to everything that you do in life, as well as in your career that you're going to take one day. So well done on excellent preparation and excellent presentations today. But take from this exercise, this lesson, that, like I say, there are no alternatives to hard work at preparing properly in any endeavor that you embark on. Congratulations and well done.
Yes, thank you. I echo the words of my brothers and sisters. I think you did an excellent job. I am pleasantly surprised at what I have heard. It's clear that you were thoroughly prepared to argue your respective cases. I think just a thought that I should leave with you is that you have now experienced how you can harness the Constitution to argue causes, to help other people. I would be glad if you take what you have learned whilst preparing for this back to society and also teach your colleagues, your fellow learners about the Constitution. And whenever you see that a right is being violated, you should speak up. Thank you.
I'm number 7 in the queue, so I'm not sure how I can express differently what's already been said. I suppose that's the challenge many of you would have experienced in preparing for today. I agree with everything my colleagues have said, but I'll add this. The most difficult thing is standing up, putting yourself forward and standing up. And each and every one of you, through the early rounds and today, stood up. You stood up confidently at the podium and you spoke. You maintained good eye contact. All the other things you're going to learn, how to present a case and the technicalities of it. You'll learn that with time. But the thing you can't learn is having it within you to put yourself on the line. And for all of you who've done that, not only today, but through the course of the competition, I say congratulations to you, because that is the most difficult. Someone has to be it's like the matric dance. One day you're going to attend one of those. Someone has to get onto the dance floor first, and then everybody else follows. The Constitution provides the platform for you to be the one to stand up and raise the issue, to take up the cudgels. And each of you who've done that today, I say well done. You've taken the first step. And I hope that your journey forward doesn't end here with the law, but that you find yourself further down the line. Well done.
but we must also know how to respect those rights. And I'm hoping that what you've learned in this exercise is that there are rights, and with rights also come obligations. And it will be a great comfort for the rest of South Africa to know that we all recognize not only our rights, but we recognize our obligations. Some of you have made the oral submissions, but the preparation of a court case is always teamwork. Someone will prepare the oral argument, but that is dependent on the work that somebody else has done. The research, the formulation of the arguments, and you've all contributed to that. And written argument is as important as oral argument, because that is what the judge first reads. So to all of you who have contributed to the argument, it was as good as standing up to address the court. So we wish you well, and I share all the sentiments expressed by my brothers and my sisters, and hopefully we'll see you appearing in our courts. Thank you.
I have children that's your age, and the one question that I always dislike people ask them is, what do you want to become when you're grown up? Because I always tell you, you already are. And I think that's the message that I want to bring to you today as well. You are already interpreters of the Constitution. We all sitting here are interpreters of the Constitution, and you did it so well today to bring out your arguments, to show us how you engage with the sections. And I want you to think, every time that you think about what is fair and just, you are practicing a very important job of understanding and making alive the Constitution. So some of you will grow up to be lawyers, some of you will grow up to practice law, you already are, other things. Some of you will, even when you are not in the law, still apply the Constitution. So I want you to hold on to that. You don't need to be a lawyer to be an interpreter of the Constitution and to practice constitutional law. But even now, you share special responsibility. You stood up for what is fair and right, given the arguments that you were asked to argue. And I think that's very courageous, and I think well done.
Thank you, my brother. I would like to say congratulations to all the team members that made it this far. Whether you had an opportunity to speak today or not, you did well. I would like to concur with my brother Wilson about his observations regarding the pace adopted by the speakers. You know, us as judges, we are old school. If you speak too fast, we struggle to hear you. And it's very important for you, if you become a lawyer in future, to know that you must present your submissions in a clear manner and make sure that your audience being the judge or judges that you are appearing before, they are with you. Don't leave them behind. Keep the eye contact. Make sure that they follow you. My brother has already said that you must take a deep breath when you start. That will regulate your pace. Again, you worked as a team. Please build on that, because at the workplace, you require, or a team spirit is required. So you must build on your experiences. those that are not going to be announced as winners today, it doesn't mean that you are failures. I know that some people are perfectionists, and when you're a perfectionist, you are hard on yourself. You will feel that you could have done better and have sleepless nights. So I want to assure you that you all did well, and I would like to congratulate you. Thank you.
Okay, thank you, and thank you to my brothers and sisters for their contributions as well in giving you the feedback. And I think what's probably the most reassuring thing for me is that this case that you've argued today is not a one-off experience, in a sense that whether you become lawyers or not remains to be seen. But I'm hoping that it is reflective of who you are. Because if we speak about equality today in a court of law, then when we leave the court, we have to live that, not so. We have to treat each other with respect and with dignity. We can't leave almost the arguments on the desk and say, well, now life goes on. And that's often the problem in our country, that people speak about rights and they speak about their responsibilities, but we don't often live it. And we don't have to be lawyers to live it. We just have to be human beings to understand that in each one of us, there is a fellow human being, different, but who is worthy of respect and of dignity. And if we all leave here with that, then I'd be very happy. So my last task is to announce the winning team and the winning oralist. In announcing the winning team, we looked at how the team complemented each other, how the argument was divided. And the announcement is not based on the merits of the case. So we're not announcing our judgment as to which side won the case, as it were. Deputy Minister, that judgment has been reserved. What we're announcing is really the team that presented the best oral arguments. Sorry. Now, you want us to stop now? Okay, or do you want us to do that? Sorry? Yeah, 'cause I thought this was the... Okay, so we looked at how you worked together as a team, and how you complemented each other, and how you separated and divided the argument, and your engagement with the bench and the conversation, the dialogue that some of my colleagues spoke about. And the winning team is the team that represented the respondents. Thank you. You may be seated, and thank you. It seems that the winning team can't handle the noise, so but that's an indication of the appreciation that the audience have, and the best oralist. I mean, you all did well. At the end of the day, only one person could win. And the unanimous view of the panel of judges is that our winning panelist today is Miss Johanna Moredi. Congratulations, Ms. Maredi. You did exceptionally well. And okay. Okay. That concludes our role, and we can adjourn and then hand over to you, because I thought we'd do that way. And so do you want the judges to come down?
Okay.
Or do you want a 5-minute break?
No, we'll move straight ahead with the prize giving. And I will give guidance, Chief Justice, on how we're going to do this. It's going to be done in segments. Or are there some judges who need to leave? Oh, okay. Maybe then let's do that. Let's allow them the opportunity, those who are pressed for time, to exit the room, and then those who are left will help us with the prize giving.
And the prize giving is down there?
The prize giving is going to be down here.
So.
Okay, so do you think we must roll in the next 15 minutes? Oh, okay. 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 Okay, so that's the announcement. Just to repeat it, all the judges will come down to take pictures first with the winning team, and then take pictures with the runner-up team, and then thereafter we'll allow those who need to leave, and then we'll continue with the prize giving. Winners ke phakamani kaloku bantwana bam. Hambani. Oh, to save time.
Yeah.
Okay. 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 All right.
Yeah.
Okay.
And then maybe we can quickly set up a no visa on us.
Sure.
We say coordinators.
Sure.
Yeah, and then live on over busy. Malanga, Western Cape.
Yeah. No, Uzawabiza, I'll call you to call them when the other judges that need to leave have left.
Okay.
Yeah?
Okay.
Yeah.
Okay.
I'll call you. Okay, please coordinate the kids. Okay, colleagues, you might as well just give them their stuff whilst they're taking the photos once and for all. Yeah, hand them, give them. There's the fourth one. He looks like a judge, I know. Okay, photographers, 8, 7, 6, 5, 4, 3, 2, 1. Thank you. You can go.
Thank you, team. You can go back.
Make it quick. Now the runners up.
You done? Come and stand here. Move that way. All of you move that way.
Ambanka, look, guys, your time is over. Photographers, 8, 7, 6, 5, 4, 3, 2, 1. Thank you. Okay, one last one before you go. The best oralist. Huh? or with the sponsor. It's SM Patel Attorneys. But sponsor, we know you sponsored, but let's get somewhere where you don't. Yeah. Okay. Okay, sponsor, thank you. Sponsor. Hey, stand on your sides. Yes. Shame, it's the first time he's sponsoring, so he doesn't know this. Okay, 5, 4, 3, 2, I win, man. 1. Thank you. Okay. So now, before some of the judges that are pressed for time leave, we're just handing them over their tokens of appreciation for the work that they've done. We know that they had to sacrifice their time with their families to be here with us. So those are going to leave. We'll release them. I'm going to call you now. Okay. All right. All right. At this point, can we release the judges that are pressed for time to go? Okay. Please, I don't want to be held accountable for delaying them. Yeah. Yeah. Okay, we are fine now. No. Okay. But they have to go. I will release those ones. Okay. No, so now you will do this for me because I have to now think, I have to be agile. Only the ones that are pressed for time can exit, but everyone else can just stay. And I'm going to invite the Deputy Minister to now join them for the rest of the prizes. Yeah. We're eliminating the pressure. So the justices are also pressed for time. Oh. No, you don't have to. You can stay here for the rest of the prizes. Pardon? No, it's not going to be long. It's going to be 5 minutes. It's like... yes. Okay. All right. Now let's do this. Melifuka, you want me to announce these ones? It's the 3 of... Okay. Let us start with the most improved province for implementation. The award, and you must please run to the front and receive your certificate of acknowledgement. It goes to Free State Province. Make a choice. Free State Province. Are they here? But I said you must run, Mfukeng. You must run. You are not moving like someone who's rushing for a flight after this. Okay. The pictures here? Yenzani into phelayo. 6, 5, 4, 3, 2, 1. Thank you. And the best implementing province goes to the Western Cape. Are you back? 5, 4, 3, 2, 1. Thank you, photographers. And the best coordinated province goes to Mpumalanga.
4, 3, 2, 1. Thank you. Yeah. We already gave the Zipelel. So we only have one now, which is the best essay. Okay. Iya kubani sis? Nayo kaloku. Oh, okay. Okay. For these awards, it's the best overall essay, as I told you, that they write essays in order for them to be admitted into the oral presentation section of the program. The other one goes to Unalinna Rahube, and the other one goes to Tanaka Mkonyamo. Both of them. Okay, can the Northwest coordinator please come and collect for their children? From Kopanang High School. At least there's something for you as well, Northwest. It's not that bad. 5, 4, 3, 2, 1. Thank you, photographers. They've already taken, remember, we started with them. So we are done now. Yeah, guys, this is how hard it is to be a program director. They come and they whisper things in your ears. So can we release the judges to go back to the bench so that we can then do the vote of thanks? Thank you. Thank you, judges. Give them a round of applause. Okay, we are almost done. You are going to be served lunch later on when we say amen. But before we say amen, I am going to request the CEO of the South African Human Rights Commission, Advocate Crystal Pillay, to deliver a vote of thanks. This is the one who fights that you have money to do this. So you had better give a round of applause.
Yes, at least we can all see where the money is going to very good use. Good afternoon to you, Program Director, and to everyone present today. Please allow me to stand on the protocol that has already been observed by the speakers who have spoken before me. Firstly, I'd like to say congratulations to the winning team. It was indeed a job well done, and as you have heard from our esteemed judges, your hard work and your commitment has paid off, not just today, but for the entire duration of the program. And the same, of course, goes to our runners-up. You are indeed winners too. And you have come this far in the competition through the same degree of hard work and dedication. You would have heard this already, but I think it's very important for me to say to all the participants that this competition is not only about winning. It's about learning, it's about growing, and it's about finding your voice in the justice system. And in this regard, you have all achieved something remarkable. And let me congratulate each and every single participant from the beginning of this program. Whether you stood to argue before our esteemed judges, spent sleepless nights preparing your submissions, or supported your team from the sidelines, you have all displayed an extraordinary level of intellect, passion, and maturity. And I can say that the future of our legal system, and indeed our democracy, is in capable hands. In delivering the vote of thanks at the close of our National School Moot Court competition, on behalf of its partners, the Department of Basic Education, the Department of Justice, and the South African Human Rights Commission, I extend my deepest appreciation to everyone who made the 2025 edition a resounding success. The partners acknowledge the efforts of the broad range of strategic stakeholders who are tirelessly contributing to building a culture of human rights through this program. I said this last year, and I'd like to say it again. Having said this last comment, I'd like to see some of you join the South African Human Rights Commission in the near future. I want to make special mention of our following stakeholders: the executives, the ministers, deputy ministers, leadership of the South African Human Rights Commission, who continue to champion for this program. More specific mention goes to our Deputy Minister of Justice, DM. We really appreciate the continued support that you provide to this program, always ensuring that you are here present, joining us in its finalization as well. To the Office of the Chief Justice, the Constitutional Court, and all esteemed judges who adjudicated today's grand finale, thank you for your time, thank you for your wisdom, and for your mentorship. Your feedback and thoughtful questions not only challenged our participants, but they have indeed inspired them. Justice Jody Collopin, in absentia, thank you very much for leading the bench today. The legal fraternity, including all advocates, attorneys, magistrates, legal advisors, and law firms that provided pro bono services in coaching and adjudicating on the essays, the provincial round phases, and the semi-final phase, thank you. As partners, we acknowledge the contributions by Cliff Decker-Hofmeyer and SM Patel attorneys for the sponsorship of additional resources and awards. Thank you for investing in our youth and in the future of justice. Your support is a statement of belief in the power of education and advocacy. All institutions of higher learning for assisting at the provincial level and essay phases. Specific mention goes to the University of Pretoria Centre for Human Rights for providing technical support and ensuring the legacy and vision of the program's founder, the late Professor Christoph Haynes, lives on. All school principals, educators, and parents for supporting and guiding the learners throughout this process. Your role in their journey could not be overstated. It has been said, and we acknowledge, that behind every confident speaker is someone who believed in them first. And most importantly, to our learners who participated in this program, your enthusiasm did not go unnoticed, and we are certain this is an important step in adding wealth to your future academic careers. Finally, a heartfelt thank you to the program implementers and the volunteers and all administrative staff who worked tirelessly behind the scenes in coordinating the myriad of tasks required to achieve this key milestone. As the acting CEO in the Commission, I'm incredibly proud of what we've achieved today through this competition. We have not just hosted the Moot Court, we've helped shape confident, critical thinkers who will one day be the guardians of justice. We are here today not only inspired by what we've seen, but committed to building a society where young voices are heard and justice is a lived reality for all. I thank you very much.
Thank you so much. Oh.
Apologies, just one more thing, Program Director, I forgot to say, I declared the Moot Court program for 2025 closed.
Otherwise, it would not have been minuted if you did not say that. Thank you very much then, CEO, for those words of thanks. I just... Yeah, where is she? Okay, yeah, you'll do that. Yeah, okay. I just want to announce to say that the judges then go back to their briefing room to have their lunch, and the officials know exactly where they need to go. They were told, and everyone else, the learners and everyone that's in the room, you get your lunch at the foyer outside, and it's a grab-and-go lunch that has been prepared for you. If you've been on an SAA aircraft, I would like to say, hambane kahle, Dotsons.
The court is adjourned.